Hello, my name is Marshall Waller, Certified California Family Law Specialist, author of the textbook California Family Law, a treatise used by students and attorneys throughout the state. I'm a fellow of the American Academy of Matrimonial Lawyers and a fellow of the International Academy of Family Lawyers. Today, I'd like to talk about tech-enabled abuse. A restraining order says, stay 100 yards away. But what if the person it's aimed at can still watch you come home through a doorbell camera? Change your thermostat at midnight. Track every mile you drive through a vehicle app without ever leaving their couch. That's what California family courts are dealing with right now. And the frustrating part isn't that the law hasn't caught up. It has. The frustrating part is that most of the relief being ordered still doesn't work because it's aimed at the wrong target. Here's something that surprises a lot of people, including attorneys. California does not need a new legal category for this. The framework is already there. Family Code Section 6203 defines abuse broadly. It's not limited to physical injury. Section 6320 gives courts the power to enjoin stalking, harassment, threats, direct or indirect contact, and now expressly includes conduct carried out through online accounts, text messages, internet-connected devices, and other electronic technologies. It covers impersonation through electronic means, and it includes coercive control, which the statute defines as controlling or monitoring someone's movements, communications, daily behavior, finances, or access to services. That language already covers the thermostat, the camera, the cloud account, the vehicle app, all of it. And the statute doesn't require a threat of imminent physical harm. If the conduct destroys someone's mental or emotional calm, isolates them, controls their movement, or interferes with access to services, it's within the statute. Two published appellate decisions now back that up. In the case AM and RY, the Court of Appeal addressed a case involving a Tesla as part of the domestic violence fact pattern. The court held the trial court erred in finding the petition legally insufficient, and it made an important procedural point. A court can't deny ex parte relief solely because allegations of abuse come up in a dissolution. The case RR versus CR went further. The Court of Appeal reversed the denial of a restraining order request and directed entry of the order. The trial court had focused too narrowly on intent and the respondent's mental health explanation while discounting repeated stalking and intrusive conduct. The appellate court was clear. The Domestic Violence Prevention Act is broad, abuse doesn't need to be intended as a threat, and past abuse can support a DVRO without a separate showing of probable future violence. The message from these cases is plain. Courts can't dismiss connected device abuse as just disillusioned friction, just because there's no punch or bruise. The question is statutory. Did the conduct fall within Section 6320 and destroy the petitioner's mental or emotional calm? So, if the law is there, why does relief keep failing? Because of a category mistake. Lawyers draft to the object they can see, not the control point that governs access. A camera is not the camera account. A thermostat is not the administrator who decides which users can adjust it. A car is not the service account tied to the VIN. The thing you can touch and the thing that controls access, those are different. Every disputed system should be analyzed on four planes. Physical possession. Who has the device, the residence, the vehicle? Account control. Who can add users, reset credentials, view data? Provider control. Which company has the power to terminate or restructure access? And proof authority. What document will that company accept to make the changes needed? I call that the control point method. It's basic, and it solves most of the confusion that makes domestic violence restraining order relief ineffective. Once you find the real control point, the legal question becomes manageable. Is this a respondent-directed injunction problem, a provider-directed statutory problem, or both? Three failure modes keep coming up. First, the order names the wrong target. Petitioner gets possession of the home, but the respondent is still an administrator on the platform that runs the locks, the thermostat, the doorbell. The court solved possession, it didn't solve access. That respondent can still disturb the peace without crossing the curb line. Second, the order overstates what the court can command. Remove all access from all devices everywhere. That sounds strong, but it often exceeds what the respondent alone can do, because the real power sits with a non-party provider. That kind of order invites enforceability objections. It invites due process challenges. And worst of all, it creates false security. The protected person assumes the system's been severed, but it hasn't. Third, counsel disconnects without preserving. Sometimes the best evidence sits in the same interface you need to sever for safety. Reset first, and the proof disappears. The sequence matters. Preserve what's lawfully accessible, get your restraints, invoke the statute, then verify. California now gives you 3 layers of relief. They only work together and in sequence. Layer 1 is the court order. Under the DVPA, the court has real authority over the respondent. It can prohibit monitoring through listed systems, bar the use of listed credentials and applications, prohibit adding or removing users, ban impersonation, and order no efforts to obtain the protected person's location. It can also allocate exclusive possession of devices, home systems, or vehicles. And those possession findings often become the proof documents the next layer requires. But specificity is what separates a useful order from a useless one. Respondent shall not use, access, monitor, add users to, receive data from, or send commands through the systems in attachment A. That's enforceable. You can monitor it, you can defend it. Compare that to respondent shall remove all access from every account and device everywhere. That's a disguised command to non-party companies, and it's a terrible fit for contempt. Layer 2 is Senate Bill 50, a provider-facing workflow for connected devices. A survivor submits a device protection request to the account manager. The request has to verify a covered act, establish the survivor's exclusive legal possession or control of the device, and identify whose access gets cut. The account manager then has 2 business days to either terminate that person's access or offer a factory reset method that removes all account holders. No fee, no perpetrator approval, no notification to the perpetrator. 3 limits to keep in mind. Senate Bill 50 isn't triggered by a restraining order matter alone. It takes a separate request. It only works where the survivor has exclusive legal possession or control, and it doesn't guarantee selective removal. Sometimes the only option is a full reset. Promise more than that, and you're inviting trouble. Layer 3 is Senate Bill 1394, the anti-vehicle stalking law. This statute reframes the connected car as a surveillance platform, not just property. Covered providers have to maintain a web-based disconnection process. You provide the VIN and proof of legal possession. A domestic violence restraining order awarding possession works. The provider terminates access within 2 business days. No fees, no account holder approval, no post-termination data shared with the former account holder. But here's the critical point. Senate Bill 1394 solves access, not title. Stop collapsing this into a property right. The smarter path is staged. Get the possession order. Use it as proof in the provider request. Kill the telematics access. Litigate title separately. This is where practitioners compartmentalize most often and where the stakes are highest. Tech-facilitated abuse becomes a custody problem the moment it touches a child's safety, the protected parent's ability to provide care, or the court's ability to create safe transitions. If vehicle tracking lets one parent monitor every exchange route, if a school portal gives away the protected parent's schedule, if a child's smartwatch doubles as a proxy tracker, those facts are directly relevant to health, safety, and welfare under sections 3011 and 3020 of the Family Code. Quarantining them under property and leaving the custody order untouched is the wrong call. Section 6323 of the Family Code is one of the most underused tools here. It lets the court issue temporary custody and visitation orders ex parte, and it directs the court to specify the time, day, place, and manner of transfer to limit exposure to domestic violence. In practice, that manner of transfer language should cover whether telematics monitoring is banned during exchanges, what channel handles exchange disputes, and what backup exists if the tech fails. Think about it. A parent who shows up at every exchange already knowing the petitioner's exact route, stop history, and real-time location, that parent hasn't honored the spirit of a safe transfer, even if they never left the car. And don't overlook Section 3044 of the Family Code. When a court finds domestic violence has been committed within the previous 5 years, a rebuttable presumption arises that custody to that party is detrimental to the child's best interest. The current statute ties that finding back to Section 6203 and includes disturbing the peace under 6320. So tech-facilitated coercive control can trigger the presumption. Those custody consequences aren't collateral, they're statutory. Tech evidence lands when it's concrete and ordinary. Don't lecture the court about cybersecurity. Give the judge a timeline. On March 3rd, 10:42 p.m., the thermostat changed after the petitioner locked the house. March 5, the vehicle app still showed the respondent as an authorized user. March 7, the petitioner got a password reset notice she didn't request. And texts from the same period show the respondent referencing her location in ways that only shared system access explains. Screenshots anchored to dates, account change notices, user membership screens, texts linking the technical event to the coercive effect. That's the toolkit. Ordinary evidence, not digital mystique. Here's where this lands. California has moved past recognition. The DVPA covers coercive control. Senate Bill 50 handles connected devices. Senate Bill 1394 handles connected vehicles. The gap isn't legal, it's operational. Match the right legal instrument to the actual architecture of control. That means drafting to the system that governs access, not the gadget, invoking the company-facing statute where it applies, and rewriting custody orders to reflect that visibility, transportation, and child-related information now run through devices and accounts, not proximity. This isn't aspirational. That's what the law already requires. The question is whether you're going to use it.